So what rights are granted? As I said, essentially attribution rights and integrity rights. With respect to attribution, the author of a work of visual art in the United States has the right to claim authorship of the work, so your straightforward attribution right, and to prevent the use of his or her name as the author of a work that he or she did not create, so a misattribution, the right to prohibit misattribution. Also, under the attribution right, the author has the right to prevent the use of his or her name as the author of a work of visual art if it has been distorted or modified, but only if that has been done in a way that would be prejudicial to his or her honor or reputation. With respect to the integrity right, the statute grants the author the right, again, a couple things. First of all, the right to prevent distortion, mutilation, or modification of the work, but only if it's intentional and only if it would be prejudicial, if the distortion would be prejudicial to the honor or reputation of the author. The VARA also provides a right to prevent destruction, but again, certain qualifications. Only for works of recognized stature, and only if the destruction is intentional or grossly negligent. The statute provides no definition for us or guidance, really, of what recognized stature is. So the case law has been kind of working on defining or interpreting that. And the few cases that have come out have suggested that the work must have intrinsic merit or intrinsic worth, and that this stature must be recognized either by art experts, the art community, or some cross-section of society. There are some specific rules about modification and destruction as applied to works that are incorporated into a building. Those get a bit complicated, so I'm not really going to touch on that. But there are also specific exemptions or exceptions to the modification right, such as would allow conservation and public presentation. In other words, the modification rights it doesn't prohibit someone's specific presentation, the lighting, the placement of the work, and so forth. Both the integrity and the attribution right are subject to the doctrine of fair use as it's applied in the United States. So that adds an element of potential reasonable use. These rights do not apply to reproductions of a work on types of works that are not protected. The last point I want to talk about is ownership, transfer, and waiver. I know today's proceedings are particularly interested in waiver issues. First of all, the moral rights in VARA are provided to the author of the work, whether or not he or she is the owner of copyright. The rights are personal to the author, so they may not be transferred. Now, with respect to waiver, this was a difficult issue. It was carefully considered and it was much debated in Congress before the passage of the act. Congress determined that a law prohibiting waiver, making it so that the artist could not waive the moral rights, Congress thought this would be too extreme in the United States. They thought the better approach would be to allow waivers, but to require that they be in writing, first of all, in writing and signed by the author, and that they have to be specific, no blanket waivers. In the legislative history, it states that the artist is better protected under a regime requiring specificity of waivers than under one where an ideologically pure no waiver law is in fact rarely observed. So the combination of requiring a writing and requiring specificity is the approach that's been taken. And this writing requirement is important and is, well, in this respect, several years ago, the Copyright Office did a study in this area of waivers. And what they determined was that contracts relating to the arts, the type of works covered by VARA, are typically not written. They are typically oral agreements, and consequently, there are no written waivers, or it's rare that there are written waivers in contracts of this type or art transactions of this type. Now, one exception to that is art that is involved in buildings, art in a lobby of a building, art incorporated into the structure of a building. Here, because of some early cases that came down under the statute, building owners have become somewhat nervous and savvy about the situation, and so typically building art, if you want to call it that, is commonly subject to a waiver. The building owners require waivers for installment art, and that is common. Otherwise, if they weren't able to get those kinds of waivers, they don't want to get involved in it. They don't want the prospect of having artwork that they can't modify, alter, get rid of, remove from the building, etc. So in sum, the Visual Artists' Rights Act is an attempt to balance artist rights with commercial realities, to recognize the attribution and integrity rights to a degree without unduly interfering with the marketing and distribution of the works, and also to avoid the potential chilling effect that may come with overprotection in this area. Thank you.